Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. We talk about domain name legal news. We discuss recent UDRP decisions. There's three hosts to the show. My name's Todd Ryan. My co-hosts are David Michaels and Jeff Neuman. I'd like to say hello to my co-host before we get rolling. Hi, David. How's everything going today?
All right.
Okay, leave it at
That's
that.
cool.
You don't need to expound. Everybody that's here knows that's how David is. He's real curt, real short, real to the point. Hey, Jeff, how's everything going with you?
I gotta just say that every time I hear David give an answer, I'm always thinking of the movie Major League. I know I said this before, but you have Bob Uecker in a announcement booth with another guy who's their color coordinator or color commentator, and Bob Uecker says something about someone making a play or something, and he turns to the color commentator and says, "And what do you think about that?" And he goes, "It's all right." And then then Bob Uecker says, "Well, you don't pay him the big bucks for nothing." Anyway,
Well, at least when I throw it to David, he comes off mute and answers. I mean, you do too, but I'm saying I'm in other rooms and people want to be guests on stage or in the and you invite them and you go, all right, so what do you, and I throw it right to them and they don't say anything. So, yeah, I'm thrilled when just knowing David's there. That just tells me when he's shorter with his answers, I know David's ready with the cases. He's all ready. Well, today we are going to have a guest speaker, guest co-host is what I call Igor, because he was a panelist in one of those decisions. Actually, no, I'm wrong there. He was actually the rep for the respondent, for the domain owner in one of the decisions, the offer B case that we're going to be talking about. So I want to say, hi, Igor. How's everything going with you? How's everything over in Serbia right now?
Hi, Todd. Hi, everyone. Hi, guys. Everything is fine and great to be here. Look forward to the show.
Nice. It's good to have you. I did invite Steve Levy and John Berryhill. They might just come in and listen. If Steve gets here, he said he'd make a comment. John may or may not. And also some other friends I invited. We'll see if they show up just to listen to some interesting cases today. And the cases are cmocoaches.com, which is a domain that was stolen. And John Berryhill represented the complainant in this case. We'll get to it in a little bit, but Steve Levy happened to be the sole panelist on that case. And we'll talk about that. And then Offer B, that's OFFERBEE.com. Interesting case that Igor was the rep for the domain owner, for the respondent in this case. And that's an interesting case. And I have some questions for Igor there. And then a real interesting case, in my opinion, it's the Temco case, TEMCO.com. Boy, as a domain owner, a domain investor, large portfolio, has been part of quite a few UDRPs, was the domain owner in that case. And interesting decision from that three-member panel. Before we get to our cases, there's just so much interesting news in this space. And I want to say, I was mentioning on the show I do with Josh on Thursdays, the DNX show, which this week we are going to do a show. Josh and I are going to be in Las Vegas, so really we're going to, the burden's going to be on Arif to hold it down from the studio, although I am going to jump in. We're going to be playing pickleball at the time. So, by the way, DNX is sponsoring the pickleball, so I'm sure Josh is going to be busy when we do the show on Thursday, but I'm going to jump in and give you some live commentary from the ICA. I bring it up because on our last show we were talking about, or at least I was whining about, why cannot us domain investors have an opportunity to, when we let names expire and they go through an expired auction, why can we not share in that revenue that comes in, basically the expired auction sale? Because when you sell it privately, just no one is there to bid on your names, hardly anyone. When it's an expired auction, there's just so many bidders. Well, today, I guess they've been, planning it, but I don't know if today was the announcement. It looked like it was Atom Edge, ATOMEDGE. So Atom, formerly known as Squad Help, right? They have this new product coming out called Atom Edge, It is I mean, very interesting. It's basically, since they're a registrar now, they're doing all sorts of things for people to keep their domains, or have their names registered at Atom. One of the things is, if you let your name expire, they'll auction it off, and you as the domain owner gets to keep 40%. So this is exactly what I was talking about. I think Namebright is doing the same thing with Dropcatch. We may see some other companies in the future even doing this, but I do think it's about time. Did you know anything about this, David?
I just heard about it 10 minutes ago, and I'm reading about it. So there's 250 appraisals per day. You get at-cost registrations and renewals and transfers, discount redemption fees. It seems to be like a really interesting opportunity. The industry's getting shaken up there. So
Yeah, I wonder if there's going to
who
be a
knows? I think I
special
might
of
try it out.
transfer in domain names. Jeff, did you stay up on this? Did you know these changes in registrars? A lot of people becoming registrars now. There's some in the hopper that are going to be registrars in the future. Like I said,
I
go ahead.
did know, yeah, I did know, I did, not didn't, I did know that Adam was intending to become a registrar in its own right, but just read the announcement like everyone else did a few minutes ago. So, but usually I'm not, because I'm not one who buys and sells domain names. It's not, I'll see an article here and there, but it's not something I'm pay too much attention to.
Right, it's just industry news, and it's really not a legal issue, and that's what we talk about, legal news here. So it's something I'm going to certainly bring up on Thursday. This week, since, like I said, we're going to be in Vegas, but I'm going to talk with DARP, and I look forward to really getting details about this new product. And then, of course, we'll mention it this Thursday on the DNX show, and then the following week we'll dive into it to see what it's really about. I think some, couple interesting pieces of news before we start. There was this, if you're, well, I'll talk about the new round, the next round of GTLDs. If you're looking to apply, reach out to Jeff and myself. We have a company, TLD Strategies. It's a partnership we put together. You can go to tldstrategies.com, set an appointment with us. I bring that up because there's a couple news articles. One, you guys know Comlade bought Markmonitor, and apparently they're going to name the company Markmonitor Group. So they're, I would say, a big, when I say a competitor of ours, yeah, with regards to assisting companies that are applying for the next round. Of course, they're big corporate domain, I was going to say domain name management. Anyway, do you think a good idea, Jeff? You worked for Comlade. You think Markmonitor has better name recognition? What do you think about that name, Markmonitor Group? That's the new name.
Yeah, definitely. Markmonitor's got more name recognition, especially in the United States, and everywhere except for maybe London or the UK. Markmonitor is definitely the better known entity. So yeah, if you're going to choose between the two, you stay with Markmonitor.
Yeah, Comlade based out of London,
The
so
problem
I
with
can understand that. Go ahead.
Laude, Jeff, did you ever notice that they were losing emails? Because that name is hard to spell. Like, who can spell it correctly? First time I hear it.
I mean,
What,
Markmonitor?
Markmonitor Group?
No, comlade.com. Because I have a client who is a Comlade customer, and when I was looking at their emails, they're long. The spelling is not standard. So who would know it? Like, that's when you just,
Yeah, I
it
mean,
has no word of
look,
mouth.
it's a whole play of cum laude, which is a graduating with honor. So it's a play on honor and the domain name space com, right? So yeah, when you know cum laude, you pretty much spell it right. But I agree, Markmonitor, again, more name recognition, probably easier to remember name. You don't have to worry about the misspelling. But again, it's mostly done because of how recognized Markmonitor is. Markmonitor, had like twice the amount of clients that cum laude had, at least. I'm just kind of estimating there, but they were just, it was the acquisition nobody really wanted. So people kept acquiring them either through bigger purchases that included Markmonitor or, um, you know, other companies that did similar things. But everyone then, within a couple of years, wanted to resell them.
Yeah,
And
brought up that.
part of it's because of the manual nature of what they do. You would think that, oh, I can do so many things to automate the functions, but corporate clients don't want automation. They want to be able to pick up the phone and talk to a human being. And as you know, um, we would think, well, why wouldn't they just want a tool that could do everything for them? But I can't explain it. All I can say is the years that I worked there, the people that I know at these corporations, they're very old school. And if you give them a choice between a tool or calling a human, they're going to call the human.
I'd be perfect there because I'm a human tool. Anyway, that's self-deprecating, whatever they try to say that word. Okay, so I know the humans, they want to speak to a human. It's sort of like, yeah, so does my mom when she goes to the bank. It's just stupid. Humans can't drive as good as people, but people want a human to drive the car. That'll change, and we know that. And I was going to say something about, the reason I brought up that merger. Okay, so they went with the name Markmonitor Group. They're doing this. Of course, when it comes to managing, like Jeff just said, the corporations want to call somebody. What are they, managing the portfolios of of folks, and we know it can be done. It can be automated, but they're really their expense, their cost to help brands apply to get their .brand. Ridiculous, the expense, but they have been. Are they any more successful? This company like ours, what we're doing, Jeff, assisting entities in applying. Does ICANN hold any weight to, now that this is such a big company and they do have a good reputation, and I'm sure, their attorneys over there apply, fill out the applications appropriately, but is there any benefit? I mean, I'm talking, about our competitor to us, but a benefit for somebody working with them because of their name recognition, or does ICANN not consider their name recognition anything?
Yeah, no, ICANN is not going to consider them any better than anyone else when they submit an application. It's clients, right? They have the relationships with their clients. And so would you rather stay with someone who's already one of your vendors that you already have approved in your purchase order system or whatever complicated thing you have? It's very easy to ask an existing vendor to do new work than it is to get a new vendor. So, they already have the ear of the client. They have the recognition by the client. And, there's a perception out there that they can do better than anyone else. And, that's probably true when you compare them to a lot of newbies that are entering the consulting space that have no clue what they're doing, because these corporate registrars have plenty of people that go to ICANN and participate and are on top of everything. But, if I were competing against Markmonitor for a customer that wasn't already a customer of Markmonitor, they would have no benefit over me.
Right. I mean, I was going to say, if you really want to go directly to the source, someone who's spent a lot of time at ICANN meetings, Jeff Neuman has, you can reach out to us at tldstrategies.com. But we're really proud of what we put together. So if you are applying in the next round and you've talked with other companies and you want to know how we're different, please set an appointment with us. It's heating up. And I just wanted to mention there was a story I talked about a couple weeks ago, .meow. Somebody was on Kickstarter trying to raise money to apply for that extension .meow. Yes, like a cat. And apparently they raised some money, 80 grand. They're getting some assistance through that program that provides assistance for folks that have what's the program, Jeff? If you could use some financial help in applying.
It's the applicant support program.
Applicant support program. I forget the name. But anyway, they're going to be able to get 70-80% off their application fee. So that is substantial, but still there's a lot of other expenses. But anyway, they raised some money on Kickstarter and plan on applying. I thought it was interesting that we're seeing that's I'd say it's not skating on thin ice, but you really need quite a bit of capital to apply and then to operate a registry. And then, of course, to be successful, I think you need some marketing as well. So it's not free. But we're about ready to get to our cases today. We got 3 great UDRP cases to touch on. But there was one other story. It really wasn't a legal story, but it was something about CEDO. Right now there's some auctions going on at CEDO, and I thought it was interesting because David brought up, you can't spell cum laude or cum laude because, right, it's a play on cum laude. There's a domain marketingadvisor.com that shows that it's got a bid of $100,000 already at CEDO. They're doing these weekly auctions. I guess it's going to be weekly now. CEDO's good for something. They do have these auctions, and they start them at $99 usually, and they usually transfer the names. You don't get them clawed back, and so they I like the CEDO auctions. I mean, you can get some good deals, but Marketing Advisor, and that's advisor with the OR, with $100,000 bid. I don't know, that doesn't seem right to me. Anyway, advisor, a lot of people spell it with the ER, knowing that it's something going on there, meaning there must be a company that's Marketing Advisor that lost their name at bid. But if anybody is interested in the CEDO auctions, check them out. I don't know, bring that up. I wanted to get to our cases today so we can analyze these things and comment on them. So we're going to jump right in. And Igor, thanks again for being here, even though you were the rep on the Offer B case, the rep for the domain owner. Look forward to your comments on these other 2 cases. We'll get rolling with the first case, CMOcoaches.com. Okay, the complainant in this case, Night Vision Marketing versus Firman Taufik. Okay, this is an Indonesian domain owner. The interesting part about this case that I don't see a lot of, and I look forward to asking all 3 of you, why do we not see more cases like this, is John Berryhill represented the complainant in this case, which we all know John, domain name lawyer, most often is representing the domain name owner. In this case, he's representing the complainant who holds a trademark for the term CMO coaches, okay? And it's really a sort of a training service. They offer marketing training to marketing execs, and they have it's like a coaching service, let's say. But anyway, so this complainant registered the name back in 2018, CMOcoaches.com. They thought they had it. All of a sudden, they see the name is transferred out of their account in November of 2025. So the complainant files this UDRP because the name was, say, fraudulently transferred out of their name. That doesn't even make sense. It was transferred without their authorization out of their account, and they filed this UDRP. The respondent did not respond, and of course, there's a lot of things that have had. We'll go through the facts here. I'm going to first throw it to Jeff, I guess, today, and ask. Okay, so it's very uncommon that we see a case like this because really this was the case of a stolen domain name. But if you can, Jeff, talk about why do you think this was a good case to file? John, I'm sure the complainant consulted with John. John said, yes, I think we have a case here to file as a complainant. And tell us a little bit about the facts and why we don't see more cases like this with regards to a stolen domain name.
Yeah, and I'm trying to remember if they, well, a couple of reasons. I think because the information was associated with the domain name was changed. So it now looked like it was registered by this new company. Whereas, if you go in and hack someone's name and you're still maintaining control over it, a lot of thieves will not change the information over to not make it look like it's a new registration. And then it's just really kind of a theft because it's hard to argue. It's a new registration and a new registrant, especially when the information hasn't changed over. But here, there was evidence of a changeover of the registrant. There was evidence that they took the website and copied a lot of the stuff, and there were things in this case. It can be a UDRP where you can show definitively there was a change of a registrant, and you could show all of the bad faith factors. In normal hacking situation, you don't always have that information because everything from the outside, other than maybe the change of the website, looks like it's still the same registrant at the same registrar, and just it's got a change of control. But for things that you can find evidence where where there is a change of control or change of registrant, then you can put it in there and count it as a quote new registration.
So you still have to go through the prongs of showing, yes, you have the trademark, two, that the respondent, the domain owner, this new person doesn't have a legitimate interest in it, and third, that they did register it, acquire it in bad faith. So
right, and so if you can show, the key there is showing that it's registered, right? And I think by changing some information associated with the domain records, you can show that it operated essentially as a new registration.
So David, I'll go to you about, so this new domain owner hacked the complainant's email, and then the domain was transferred. And then in addition to that, the complainant in this case, John was repping them, said, hey, they're also impersonating us, and you can go to the website and see that. So it's those two facts are what was used to say that, this was a bad faith registration, or bad faith sort of acquisition, if you will. Does that make sense to you, David? And do you think, why do you think we don't see more cases like this with stolen domain names?
Well, I think normally registrars will claw back these stolen domain names. And here are some really bad facts that I blame GoDaddy or GoDaddy Rep for messing up, because if you look at, I went to securitytrails.com and I entered the domain name, I looked at the A record history and the NS records. So until the transfer happened last November, the domain was hosted with name servers at domain control. The interesting thing is, though, if you look at the A records, they change. So there are some changes that happened in 2021, and again from October to October 18th to November 1st, there's one A record at GoDaddy and then another A record at Amazon, but the DNS hasn't changed. And so that second one is like November 1st to January 5th, 2022. So it's a long time, right? 2 months. And if you look at archive.org, what you see is a GoDaddy get a price in less than 24 hours. It's an afternic landing page with a price inquiry. Like you give the name, your email, phone number, and your country, get price. So why did that happen? So my question to you, Todd, is as a, you were in the industry back then in 2018 and 2021, and you had a GoDaddy rep at the time that you can call up and they would change your landers, change your prices. Have you ever seen them do that, change your landers for you based on a phone call, if the domain was already in your afternic portfolio? Because the thing about this domain name, although the complainant registered in 2018, it was previously registered in 2004, and it was parked at a for sale page. And so what I'm hypothesizing is the prior owner of the name dropped the name, but is still remaining in his afternic portfolio. And when he got a rep, the rep made all these changes internally to bypass security protocols. So this poor business had their website down for a couple of months in 2021, and it took a while for them to remedy it. They couldn't figure out why it had a for sale page. And given all these facts, I think the GoDaddy should have proactively clawed back this name, because that's why there's a 60-day lock, and given it back to their customer who, is buying hosting from them, registered the domain name through them since 2018. Can you comment on that, Jeff? And what are the registrar responsibilities in this type of situation?
I wish I could give you a good comment on that. I mean, we've seen that registrars are very selective in when they choose to claw back a name and when they do not. I don't know what kind of evidence they were presented about the fraud or about the theft. And, GoDaddy, unless it's their mistake, it takes, unless you can prove it's their mistake, they're not willing to touch the domain.
Yeah, well, in this case, you can prove it with the A record history on security trails. But I guess maybe John Berryhill didn't do that, or it wasn't convincing enough to GoDaddy, or they just didn't care.
One of the above.
Well, the registrars, this is for, like we said, Adam now is a registrar. Unstoppable is a registrar. We know there's going to be some new registrars coming this year. So registrars have, a lot of responsibility too, and a lot of leeway. Like you said, Jeff, they'll decide. And when we say claw back, that means from another, it has to be an account, or when I say claw back, we use that term for a lot of different things, but to go back and retrieve the domain that was transferred out. What capabilities do they have? We know they can transfer when it stays within their registrar. Of course, they control it. But do they have any capabilities when they've transferred it outside of their own registrar?
No, once it's outside your registrar, no, you have no ability to force it to come back. You can certainly call the new registrar and say, hey, can we reverse this? Here's what's happened. And there have been, there are examples of that. But you can't, once that 60 days lock is up, and if the registrant transfers it away from that registrar, there's, nothing that can be done about it.
And finally,
yes, this was within 60 days. This was like within 30 days that the UDRP was filed.
Yeah, before I get to you, Igor, I have a question for you about this, because you're also a panelist and you rep complainants and you rep respondents. I want to ask Jeff again. So if a registrar still has the name at its registrar, but it's transferred it to another customer, will they? I know they can transfer back. I mean, they could if they wanted. But have you seen where a registrar will just lock a name? It's not there's been no court order to lock the name. Now there's no. I guess the UDRP has been, even before a UDRP decided, but basically, the registrars, how often do you see them lock names because of a dispute that's not a UDRP or a court case? Meaning, we know they can do it, but is it frequent at all for them to say, I'm going to try to resolve this problem because one customer's claiming that it's a stolen name?
It's got to be pretty significant, but generally not with stolen names. But, you've seen where there's malware, or they'll suspend names if there's child exploitation materials on there. But absent clear illegality, they're not gonna they're gonna wait to hear from a court, wait to hear from law enforcement or others. But generally, no, they won't get involved.
So actually, I'm dealing with a case right now where an account at NetFirms was hijacked, and there's like no live customer service with NetFirms. They got bought out by Newfold, and it's all automated, and you have to prove ownership of your account with some long phishing link that, or at least looks like phishing. Yeah, it's so totally wild. But yeah, it is locked for 60 days, and we're trying to resolve it before filing a UDRP complaint. And as for all I know, the Whois has not been changed. It's still at NetFirms or Two Cows, and it's just the owner of the account just got locked out of his account because he trusted his developer to access his account, and the account got compromised and owner changed. But his credit card keeps getting charged for the renewals and the hosting. So how's that work?
Yeah, thanks, David. We're going to talk about that sometime, about how domain owners can try to resolve issues before a UDRP or before a lawsuit is filed. We'll talk about that maybe next week. And to answer your question real quick, David, about the only time I've had an Afternic rep, or I've never had my GoDaddy rep, but I've had an Afternic rep help me make changes. But and they have via the phone, say if I said, assist me with making a lander change or something. Normally I just do it, so I can't recall, but I know, if I speak to them on the phone and give them authorization, they can, certainly have done that. Igor, I wanted to ask you about this. Okay, so you represent complainants sometimes. If a complainant comes to you and says, "Oh no, my domain got stolen," would you do sort of like what John did here? And I'm going to bring it up again. CMOcoaches.com is the domain name. This domain was the complainant GoDaddy account was hacked. The name was transferred away. There was a UDRP filed. Steve Levy was the sole panelist, and he decided to transfer this back from this account back to the complainant, because he said, even though stolen names, it's not, something that the UDRP decides on, but it also doesn't prevent a panelist, from deciding to transfer it back if they feel the name was acquired in a bad faith, and it was, and the person that owns it now, has no legitimate use, not known by that, and so on. But I guess my question for you, Igor, is if somebody comes to you with a stolen domain name, are you going to slow it down and say, yeah, we may have some recourse here, filing UDRP may be a right decision? How do you handle stolen domain names?
Todd, it's a really challenging question, because, the UDRP as such is not always suitable for stolen domain names. Well, first of all, you have to have trademark rights, to pursue UDRP action. I mean, in that particular case, by the way, the complainant had only a supplemental register US trademark, but it successfully argued unregistered trademark or common law trademark. So that was good for complainants, because it was able to establish unregistered trademark. But in some cases, maybe the complainant doesn't have trademark rights, and then if there is no trademark, if we cannot argue, let's say, unregistered trademark or common law trademark, then there is no UDRP. I mean, that's a start. Then again, the second issue is how are you going to prove hacking? How are you going to prove that the domain name is stolen? You have to provide some evidence, because the UDRP cannot be based on just allegations. And one of the challenges of these stolen domain name cases is proof of how you establish that the domain name was stolen. That's not always easy. And what if a respondent comes up and says, look, I didn't steal anything. I actually bought this domain name from the complainant. And I've seen a couple of, maybe a few UDRP cases like that, when in that case, there was no response. It was a default case. But I saw cases where where responses were filed, and then basically the panel said, look, I think there's a genuine dispute. I have very limited powers. I cannot, request further evidence. We have very limited jurisdiction in the UDRP, so I have to deny this complaint because it's outside the scope. So, I mean, there are a few tricky questions that need to be answered. It's not easy.
Yeah, no, you bring up good points that, in I think in this case, even if the person would have come forward and said, I purchased this name, the complainant had a solid case of saying, okay, you purchased it, you're still not known by this name, and the way you acquired it, well, you're impersonating So did you acquire it still, even if you purchased it in bad faith? I know what you mean. Obviously, it wouldn't have been as strong because this panelist, the respondent, didn't reply. Steve Levy, as the panelist, said, "Hey, it was acquired nefariously, fraudulently, and we consider that bad faith." Let's get to your case, and I say your case, Igor. That is the offer B case. So that's CMOcoaches.com. That was a transfer. That transferred away from this person who stole the name and went back to the complainant. This next case, and boy, we have a couple. These are both good cases. The next two, Offer B and Temco. If you're a domain investor, you certainly want to listen to these. Listen to the facts in these cases. Offer B, OFFERBEE.com. So this domain, the complainant here was Offer B Homes. Okay, this was a company that it has a portal for real estate. You can imagine selling homes, providing services, and so on. But the complainant is on OfferBHome.com. They're the complainant versus Jason Moss, who Igor represented in this case. Igor, I wanted to throw it to you and say, okay, tell us about the facts of this case and then how you prepared your response and really just how it was decided by this sole panelist. And then we'll have David and Jeff comment on some of the facts and the decision of this. Thank you.
Yeah, thank you, Todd. Well, this was a challenging case. I mean, challenging in a sense that this was a dispute between two competing businesses. Both businesses are from the United States and both offer real estate services. So when the complainant filed his complaint, the complainant basically said that, look, we offer real estate services. We help, people sell their real estate fast for cash without real estate brokers. So basically direct sales. And the respondent, look at the respondent, he does the same thing. He offers the same services. We have a federal US trademark registration for Offer B plus logo trademark. And we started using our trademark back in 2021, whereas the respondent acquired the domain name, I think it was like 23 or 20. Well, I'm trying to 24, I think, in 2024. So when you look first at this case, you think that it's kind of very tricky for the respondent because two competing services, both from the United States, and doing kind of the same thing. But when I talk to the respondent, and basically what I always do when I represent respondents, I always ask them to tell me the story, what's happened, how you came up with this name, why did you register this? And he said, look, I was looking for a name for real estate project of me, and I'm in real estate business. I'm also a YouTuber. I do some blogging and all sorts of things, but many of them are real estate related. And I was trying to find a good name, and me and my business partner, we were kind of trying to come up with a good name. We had a few options, actually quite a few options, and eventually we came up with this offerb.com because I was able to purchase this domain name from the previous owner who was not really using it. And that name was free. I was able to purchase it as a premium domain name at a certain price. And I never heard of any business, under this OfferB name, and it has never been associated with any business I was aware of when I purchased that domain name. So I thought it's a good name. And then OfferB, I was looking for something that could send a message to my customers that we offer like quick services. And offer is an offer, obviously, and B is a kind of, B is fast and speedy, and also real estate agents sometimes are kind of, compared to bees because they have to be hardworking, they have to move fast and stuff like that. So basically, that was his explanation. And then he said, look, I didn't know about this company. When they filed the UDRP complaint, I checked, yes, they do exist, but it's some small company, like I think from New Jersey, and my client was from a different US state, I think from Missouri. So never heard of them. Yes, it's a strange coincidence, but I can provide the whole story. And we filed as an annex to our response, basically this correspondence between my client, between the respondent and his business partner when we were actually selecting the name. And there were, I think, like 20 or even more options, different options. Some of them were B related or offer related. Some of them were not related to offers and Bs, and basically the whole conversation. And that was one, let's say, one of the pieces of evidence we filed. But the other issue that was very important, that my client registered this domain name before the complainant. It registered his domain name before the complainant filed its US trademark application. So our domain name registration actually predated complainant's trademark application registration. But the complainant tried to rely on unregistered trademark. The complainant said that, look, we actually started using our brand earlier. And therefore we have common law trademark rights, because look at the screenshot. We have a screenshot of our website back in 21, but again, they only provided a single screenshot, and that single screenshot is not enough to establish common law trademark rights under the UDRP. And second thing, they didn't provide any evidence of reputation of the offer B trademark. So even though at first when you looked at this case, you thought that, well, looks like a complainant have a pretty good case, but when you really look at all the facts, and when you talk to the respondent, when you basically build up a defense, then you understand that, and I realized that the case wasn't hopeless at all. And obviously, I think we filed a good response with some strong annexes. I'm glad that the panelists accepted our arguments, because clearly this was not a cyber squatting case.
Well, I think very interesting. I wanted to let David and Jeff comment on it, but I wanted to clear up some things. So the respondent in this case, who was represented by Igor, acquired the name from a broker in February of 2024 for $2,200, right around there, and then had spent nearly $10,000 to create the website. And he mentions that to Igor, and Igor brings it up in their response. The complainant, has this trademark that they've got in 2025, in June of 2025, but they say, yeah, we got the trademark then, but on our trademark application, we put that we had been using it since 2021. Well, that's one thing. When you say you first used it in 2021, you have to prove that you first used it. So, I have some questions for you, Igor, but first I want to go, David, do you have any questions, comments for Igor about this case? And then you, Jeff, and then I'm going to attack the guy. Okay, go ahead.
So how thin was the evidence of the complainant? Because I look at their USPTO specimens that they provided, and they show a Facebook page that says that they created in 2021, and they had the same domain name there, an offer be home, same logo. They're using a Georgia location, Atlanta, Georgia. There was a corporation active in Georgia at the time, but now it's canceled. So they only had 35 likes on Facebook according to the screenshot. So what other evidence do they show of notoriety? Because it seems really thin.
I think that was one of the major issues for the complainant. They didn't show any evidence of notoriety. Well, they relied on the federal trademark registration. They said, look, we have a trademark registration. That's true. That's a federal US registration. Then they said, look, we started using our trademark, our brand, let's say, our mark earlier back in 21, and they relied on common law trademark rights. But other than screenshot of their own website, they provided, I think, two screenshots, one of the old version from 21, and the second one was the current version of 25. And apart from these two screenshots and US federal trademark registration, and apart from the respondent's website, screenshots, they didn't provide any other evidence, because I guess they believe that's enough. They said that, look, he offers competing services. He's also into real estate. They tried to argue that the respondent copied the design, which is not true. Clearly, the design of two websites are pretty different. But they didn't even provide a Facebook page. Actually, I provided a screenshot of their Facebook page and the LinkedIn web page, because I said, look, they only have I think 20 Facebook followers and maybe 18 LinkedIn followers. So they're even now in 25. So they're not really known, and it's a very small business. So actually, they said that it's unclear whether the respondent offers any services, but it was also unclear whether they actually offer any services, because they're really small company. And the extent of the business was unclear. So I think that was the major issue for them. They believe that it's enough to provide the trademark registration and a couple of screenshots of their own website. That's enough to win in the UDRP. And I mean, it can be enough in certain cases. And again, in that case, what mattered that we provided response, and we provided very detailed evidence. We were very open, as Todd said, that we provided evidence that the respondent paid a website developer like over $9,000 for website development. So we provided evidence of like genuine, credible business that my client is doing and was doing under this domain name.
Yeah, it's interesting. Your client's website is actually, it takes a while to load, and it's just like a one pager, enter your information there. So it doesn't seem like it's active, but that's a different story.
Yeah, Jeff, did you have any comments or questions on this? I have some questions for Igor about the domain name and B, and then, but Jeff, any comments on this? You on a call? You're on mute. All right, well, okay, go ahead.
Yeah, I don't know why I was on mute. No, I mean, I think Igor and David covered it. I think it was well defended. Yeah, Steve's, you could count on Steve as being a pretty good.
He wasn't the panelist in this case. That was the first one. Okay, so.
Oh, I have a question.
This was.
Sorry about that. I made so there were 3 panelists in this one, right?
No, this was just William Hamilton. He was single member panelist. Hold on, I want to make some comments.
Yeah, go ahead.
So this domain was offerbee, OFFERBEE.com. Igor represented the domain owner and won. Let's say he's successful for his client because the single member panelist, William Hamilton, said, okay, so this offerbee homes, you do have a trademark on offerbee homes. We'll give you that, but it was a trademark from 2025, so it's recent, but you do have a trademark. So you do have standing, and the name is similar to your mark. It's offerbee, your offerbee home, so, got it. But the panelist said, this domain owner does have a legitimate interest, and that was probably due to the evidence, obviously, that Igor provided for the client, and said this wasn't acquired in 2024 in bad faith because, one, he didn't even know about you guys. Now, he's saying he didn't know about, and that's the question that I have for you, Igor, because this client of yours said, we did look at several names, and I'm assuming that, for one, I didn't know BEE was real common in real estate, so I didn't even know that. So I immediately thought, OfferB, this other company's on OfferB Home. They probably, your client did mention, I think you bet it, they did mention that they had searched or they had looked at several names before they settled on offerb.com. So it made me think, well, if they were looking at names and they said they didn't even register some that had home in it because they realized there were other folks that were using home in the name, not offerb home, not the complainant, but they did say they bypassed or they decided not to register certain names because they were doing some research, but yet when they looked at offerb, they didn't see this complainant at all. But even you said, so this complainant did have some a website back in 2021. It certainly wasn't prominent or something that anybody would know about unless you searched it. So how did you get around that? Meaning your client said he did search names before he picked offerb, but how did he miss seeing the complainant if he had searched offerb in the real estate sector?
Yeah, well, let's say he searched the names and he checked the names, and as he explained to me that some names came up to him immediately as being associated with some bigger businesses. So some businesses are not necessarily home related or offer related. I don't remember exactly which names were that, but they basically rejected a couple of names straight away because they were associated with some existing businesses. Both of them were aware of. And this offerb, as he said to me, that, look, I've never heard of any company named offerb. That exact domain name, offerb.com, was not related to any active business at all. And this complainant, offerbhome.com, again, they didn't check every offer-b domain name. That's for sure. But that complainant had very, very low visibility, online visibility. And when I actually started searching myself, because when he told me this story, I thought, okay, I need to check this, because yeah, that's a kind of strange coincidence when you have two companies doing very similar things, both in real estate and both having B in the name. And again, this is not a descriptive term. This is not a descriptive mark, because yes, we can say that Bs are kind of used in real estate, but again, it's not so widespread. We found some businesses, some real estate businesses that use the B or Bs. They exist, but it's not like there are hundreds of them. We found a few, and I provided them, as some of these examples. But basically, when I checked this information online, I really didn't find much about the complainant. And then I realized that actually respondent was right. The respondent was right, yeah, because they didn't really have any. Well, they had very low visibility, so to say. They had like Facebook page, which I kind of digged in and found, and again with very few followers, this LinkedIn page and the website, and that was all. Then the question is, of course, and I think that question is maybe more related to the third case, to the last case, how deep you have to dig. When you do a search, let's say, how detailed your search should be. And when you do a prior search, when you register a domain name, how far you should go in your search. And then, we can argue about that. But this guy is, is a businessman, and he believed he did enough when he was, when he was trying to find a good name for his business. When he registered his domain name, this domain name was not associated to any business he knew. And that was a challenge, of course, but we had to explain this to the panel. And of course, you never know how, especially in a single panel case, you never know how the panelists will respond to your arguments. But I think he made a pretty good decision, and I think I'll give him special credit for this second element, because often in WIPO decisions we see that panelists tend to skip the second UDRP element, like legitimate interest. But he actually found for respondent on this, because he said you provided enough evidence that you're doing some legitimate business under this name. So this was a challenging case. But again, when you look at the facts of the case, when you talk to the respondent, then you realize that his story makes sense, even though at first it looks kind of maybe tricky.
Yeah, I will say I agree that the panelists made a good decision in this case, and I do believe this was coincidental, because even though there was the complainant on offer-b home, and they did register that name, offerbhome.com, back in November of 2020, they didn't have an online presence, and you can't expect the domain owner. I certainly hope panelists don't in the future expect domain owners to use domain tools or .db and look up how many other domains have the term that we're registering, like offer-b, in the domain name. I mean, basically, I don't want the domain owners to be responsible. Their panelists sometimes already make us responsible for check to make sure there's no live trademarks on this. I mean, what a research are we supposed to do before we register a domain name? And many times I think it's beneficial if it's generic. Sometimes you don't want to know. I guess my point is I really look forward to getting to this next case. So the offer-b case was a great example of, if this domain owner didn't have representation, didn't have Igor helping him, representing him in this case and answering back, the solo panelist may have still ruled in his favor, a complaint denied, but it's much more unlikely. So even that, this was it considered coincidental because of all the facts that Igor brought on behalf of the domain registrant in the response, because otherwise we would have just had the complainant making their case, no response like we normally see. In this, in my opinion, probably would have been a transfer. So very important to get representation if you have a domain dispute. And of course, you could always ask Jeff, ask Igor to help you out. They're both, they'll rep you as a domain owner, they'll rep you as a complainant, and they're also sometimes panelists. All right, so offerb.com was a complaint denied. Congratulations, Igor, for the successful representation of your client. This last case is very, I think, very interesting. And thanks, Igor, for being here. Jeff has a call with a client, so he's had to jump off. But this case is really important. temco.com, domain name registered back in 1996. I'll make the longest story short. Temco, Temco Industries, was the complainant. They filed this against Mira Holdings. And David, I'm sure you know as well, Igor, Mira Holdings, domain owner, they've been a respondent in many, dozens, it seems like, of UDRP cases. So both, in this case, the complainant and the respondent were internally represented. So I don't see any big lawyers attached to the complainant. And it looks like Mira Holdings, he's an investor out of Minnesota, I know he's used, I think he's used John before. I think he's used Jason Schaefer before. Bottom line, and I will say, in this case, he did answer, but I think he should have used some counsel, because we're going to talk about, I'm going to give it away right now. He lost the name Temco. Basically, it was transferred away by a 3-member panel, and it's a really, in my opinion, a terrible decision. And it's a terrible decision on really for a couple reasons. I want to say several reasons, but at least a few. So let me give you some facts. Then I'm going to throw it to David, and then you, Igor. Please, I look forward to you both of your comments on this. The complainant is a tool manufacturer in Texas since 1968. Okay, they've been selling online since 1999, and they're on the domain temcoindustrial.com. Okay, they also sell on eBay and Amazon and stuff like that, but it's a big company. They happen to be one of many companies that go by the name Temco. So they do have a trademark for Temco, and so basically it wasn't difficult for them to pass this first hurdle, meaning they did have standing to file this case against this domain investor. And the domain investor did answer, and he said, listen, I purchased this name in 2022 for $12,500 on NameJet. It resolves to a GoDaddy for sale page. I bought it because, it's just a great 5-letter name. I've sold many names that end, just like this, 5- and 6-letter that end in CO. I have some myself. I love them. Anyway, that's why I paid $12,500 for it. Put that in his response. And some other interesting facts real quick are that the complainant, contacted the GoDaddy broker to inquire about buying this name. And they basically, the GoDaddy broker said the domain owner wants $150,000 for it. The complainant offered $5,000. The complainant made several offers. Basically, the domain was priced between $50,000 and $180,000, but this complainant ended up lowering his offer. He lowered it down to $1,000, and then I believe the best counter for the complainant from the respondent was $48,500. So that was the lowest counter. But anyway, the complainant ended up filing a UDRP in this case. The respondent tried to show that there's a ton of other trademarks and so on, but it was really the inquiry to GoDaddy and GoDaddy's response that really worked against the domain owner in this case. So David, I'm going to go to you. Please add in those other facts of why this ended up, turning the 3-member panel turned against the domain owner, after learning about the communication between the broker and this complainant.
So the broker was telling the potential buyer, hey, the seller has decided not to counter currently as the offer is simply too far apart. The seller said they are willing to wait for the right end user to purchase this name with a stronger offer. Example, Temco Industrial, Temco Logistics, Temco Parts, and .com would all be greatly benefit from owning this name. And this is in quotes from the broker. Now, whether or not that actually is the case, or did the broker make this thing up, is a question that we don't know the answer to. I looked at .db. Temco is registered in 67 TLDs. 445 domain names start with the word Temco. A lot of them are .coms. There are 282 entities around the world that are active with the word Temco in it, and many of them start with the word Temco. 23 Delaware corporations, 5 in Florida, 7 in Australia. In fact, Australia gets a lot of search volume on Google Trends for this. So the fact that this name was sold on Namejet, an expired auction, but it did not drop, means that it still retains the original registration date. But there was a whole lot of people bidding on it because it got up to 12,000 and change. So this is the kind of name I probably would have bid on because, hey, there's a lot of opportunity here. But I guess maybe this language from the GoDaddy broker really did them in. They should have hired a good UDRP lawyer to respond because they didn't address the fact that there are 69 trademark owners globally, 10 of them in the United States that are not associated with the complainant. So there are plenty of cases saying that, hey, if they don't have exclusive rights, there's no evidence of targeting, it's insufficient to prove bad faith. So I think that would have made a huge difference, but they didn't do that. They just said, oh, it's like a legitimate business, we're selling domain names and it's fair. And that's what they focused their response on, and that's not enough. So those are the big points that I have. How would you have addressed this differently? Igor, would you have said more than that?
David, it's not an easy case to comment on for me as a panelist, because sometimes we as panelists we have to deal with some really complicated cases and some uneasy and tricky issues. I think this is one of such cases. And again, without seeing the submissions, sometimes it's really hard to say what could have been done. But again, I was surprised, let's say, without even looking at the facts, when I saw the outcome and knowing the respondent. I know this respondent, of course, Mira Holdings, a well-known domain investor, and I think they've been successful, I think, in the recent domain disputes. And but I agree with you, David. I think one thing definitely, I think maybe for that particular case, they should have hired some experienced UDRP lawyer, because my understanding is that they were self-represented in all of the recent cases, or at least, they don't have any representative in any of the recent decisions. So I guess they have enough experience, and probably they can handle most UDRP cases themselves now. But maybe for that case, they needed some extra help. And another issue, which I think you mentioned already, this broker who mentioned the complainant as one of the potential buyers. And I think that kind of influenced the panel maybe in deciding in favor of the complainant, because I guess they saw this as a sign of targeting, so to speak. But that's a tricky case.
Well, let me comment that, okay, so this name was transferred away from this domain investor because the panel basically said, well, you're targeting one of the trademark owners. That's basically what he said. So because the broker said, hey, this seller wants to sell it, for more than you're willing to offer it. And we believe there's going to be some companies out there like Temco Industrial, Temco, whoever, Temco this, and brought up a few and said, we know these companies, for example, could benefit from this name. And the panelists took it in as, okay, so they're targeting trademark owners. So in Temco Industrial, the complainant is one of the targets. Okay, well, why domain investors were frustrated with this? Because sure, I think the answer from the respondent should have been, like David said, there's 65, there's 68 trademark owners, plus there's at least that many potential in the future users that aren't even using this term, TEMCO. So not only could existing mark holders benefit from this, but potential future users could benefit from this type of name because it's so attractive. It's a 5-letter ending in CO, and it's great letters, the TEM. So I think if the respondent mentioned all that, it surely couldn't have hurt, could only have benefited. But for some reason, it's bullshit. This is what I've always talked about. So if you have 10 trademark owners or 60, then are you allowed to register a name? Because you're showing that many different companies, have basically have this term in their mark. So this panel basically said whether it's 3, whether it's 20, in my opinion, this is how I interpret it, whether there's three companies that have a trademark Temco in it, or 50 or 60. If you're targeting one of these mark holders, or all of these mark holders, then you're targeting. So they just looked at it as you're targeting. I think the addition of saying, yeah, I'm also looking to sell it to someone who may want to use this mark in the future that's not a current mark holder could have certainly benefited, but just a terrible decision. So anyway, I'll just say, yeah, these 3 panelists, and I'm surprised. I thought Matthew Kennedy, but anyway, Christopher Gibson was the presiding panelist. Matthew Kennedy and John Swanson were on this, but yeah, as a domain name investor, you're spending this kind of money on a name. They did mention, the panelists did mention, yeah, Mira Holdings has been part of a lot of UDRPs. They've won other, IPGuardian.com was a case they won, and the panelists brought up, yeah, because IP and Guardian are 2 generic terms, and you put them together, okay. But Temco, they felt just is not generic. Just whatever, they can make, it's unusual. A single member panelist, I could see making a bad decision, and I can think of certain panelists that love to side with the trademark owner. But 3 panelists, and then the name is TEMCO. I mean, bottom line, Igor, I got to say, it's 25 years later, right? These panelists, everybody's pretty smart now. We know there's domain investing. I don't care if this domain investor lost 20 cases in a row. This case should stand on its own. And if a panelists can understand this and see value in TEMCO as a brandable domain name, or as a name, and then knowing the facts that this guy bought it for 12 grand at auction, like David said, there was other people that were bidding on the name to get it up to 12,500. Were those any mark holders that had a right to and decided to back out, or other investors? But I just think this is anyway a terrible decision for domain investors, because it's really saying that in many cases we see domain investing is considered a legitimate legitimate business, and in this case they basically just threw it out. But before we go, so this TEMCO.com was transferred. I look forward to the ICA meeting to talk with a lot of the lawyers there, from Jason Schaefer to John Berryhill to Stephen Lieberman. You need to go through them. Jeffrey Neuman. There's also Ari Goldberger's going to be there. It's like, now I realize there's just going to be so many lawyers there. I can't wait to talk to them really about this case. But any final comments, Igor, on this thing?
Yeah, Todd, just wanted to add on the search issue, because I think one of the important aspects of this UDRP decision was panels, comments on trademark and domain name searches. And again, I think this is a big issue, because again, whenever you register a domain name, I mean, you as an investor, or just anybody, you don't have to be an investor necessarily, then it's always a question, how do you have to check whether there is a company, there's a business, there's a trademark with the same or similar name in this business or in any other line of business if you want to start a business? Like in this OfferB case. In the OfferB case, there was no registered trademark. When the respondent was registered the domain name, there was no US, even no US trademark application, but there was a company already, there was a website. So then again, it's a question, do you have to check, do you have to Google, do you have to do a USPTO search, do you have to search like WIPO database and so on and so forth? Here, I think in the Temco decision, the panel said that the respondent provided some search results, and the respondent actually argued that there are a number of companies with the Temco brand name and with trademark, but then I think the panel said that, look, it shows that the respondent is sophisticated. So, and because it is so sophisticated, then it should have known about the complainant. That's a very interesting argument. And again, it can put, very big obligation on UDRP respondents. You have to do the searches, and then you have to, how you have to decide, which one, let's say, is the potential complainant, and whether you should register or you shouldn't register. So I think it's, it's not easy to comment on that case. I agree. It's very, let's say, very arguable decision, and I think there are going to be lots of arguments about this case. And it's a 3-member decision, and in 3-member decisions, it's respondents always have better chances. But probably again, maybe in that case, maybe the respondent should have hired a professional domain name lawyer. Maybe just in that case, but again, we didn't know what happened, and we didn't see the submissions. We can just guess.
You know, as we're seeing, and you know this from some of the calls we're on, Igor, that there's some, well, there are some attorneys that represent complainants that feel when you say you're a professional domain investor, you are held to a higher standard. You should know you're buying a portfolio. Well, you should know what's in that portfolio if you're buying something that's infringing on somebody's mark, or certainly if you're buying an individual name or you're bidding so much on it. So, you're right. When you'd like to see that people are using the domain investor excuse, or I was going to say domain investor reason for a legitimate business in a response. But now we're realizing, okay, some panelists hold domain investors to a higher standard about doing research before they purchase a name. Any final comments, David?
So I'm just looking up Christopher Gibson. He is a professor based in Silicon Valley, but he also teaches at Boston. He's dealing with the Silicon Valley Arbitration Center. And he's dealing with all kinds of arbitrations, not just UDRPs. So I don't think he, as the presiding panelist in this case, really had a good grasp of the nuances of what domain investing is and why it's legitimate to grab a name where there's no one particular exclusive right holder of the name, of the brand. And so that's a shame. Maybe other panelists would have done better, but instead of paying for 2 extra UDRP panelists, they should have paid for attorneys' help to draft this response or have represent them. Just represent them. Don't try to do this kind of stuff on your own if there's bad evidence in the complaint, for sure.
Yeah, great advice. Hire a lawyer. This one, and you bring up another good point. Some people just still don't like domain investors. They think you just don't like them. Doesn't matter if you're buying 3-letter acronyms. They don't like that you're going to buy it and then you want to resell it for a lot. And some people, especially attorneys and panelists, they know that's legal and it's legitimate and it's become a business, domain investing. But still, there's a lot of folks who just still don't like it. They don't like the idea. Well, that's going to be it for today. We appreciate everybody joining us, whether you're listening in here live or you're listening on replay. Thanks a lot. Once again, we'll be back here next week, next Tuesday, noon Pacific, 3 p.m. Eastern for the Domain Name Law Show. And you can listen replay here on X. We stream live on YouTube, and we're on Spotify and Apple if you want to listen to the podcast. Once again, too, on DNX show we do on Thursday. We're going to be doing that live from the ICA Meetup in Vegas this week, which gets kicked off Wednesday. So from Wednesday to Saturday, it's the ICA Meetup. If you're going to be in Las Vegas, you can still join us. Go to ICA.Vegas, and you can get details on what's going to be happening, basically the agenda, and how you can participate, be involved if you want. All right. Thanks, everybody, for being here. Have a great rest of the day, wherever you're at, rest of the evening. Thanks again, Igor. Thank you, David. Take care. We'll talk to you later.
Thank you. Bye.